Welcome to the LexIslamica video course series brought to you by the Advanced Legal Studies Institute, Islamabad. This course, Islamic Jurisprudence, is the first course of the series. If you haven't seen the introductory video to the course, it is advisable that you do so to get a better understanding of the structure and nature of the course. The link for the introductory video has been given in the description below. This video, Introduction to the Sources of Islamic Law, is the second video of the course. Let's begin. This video introduces the terminology associated with the sources of Islamic law so that the viewer becomes familiar with these terms, as they will occur in future videos. It points out that the true source of Islamic law is Allah Almighty. It then distinguishes between sources that are agreed upon by the jurists and those that are not acceptable to all of them. There are different ways of classifying sources, and each classification has a purpose. These classifications are explained in this video. The last point in this video is about the strength of the sources and the order of the sequence in which they are approached by the jurists during interpretation. We will now take a look at the terminology associated with the sources of Islamic law, and we will list down the terms used for these sources. Muslim jurists did not define the terms fiqh, Usul-ul-Fiqh, and other important terms that we know today, even up till the 4th or 5th centuries of the Hijrah. One of the earliest terms used by the Hanafi jurists for source was hujjah. The terms that came to be used were the following: hujjah, which is argument, proof, or evidence; dalil, which is evidence or gift; and asl, the plural for which is usul, which is known as the root, foundation, rule, or principle. The term masdar is also used sometimes, but it is used in modern law. It has little significance for earlier Islamic texts. The meaning of these terms may be examined briefly, as they indicate the function of the sources. We will now elaborate the meanings of some of these terms. The term hujjah as a source of Islamic law has a literal as well as technical meaning. The word hujjah in one of its literal senses means the dominant or overcoming argument by means of which one convinces another. That is, it has an authoritative nature. Another meaning of hujjah is that it is something to which recourse is to be had. This is the meaning of the term hajjul bayt, that is, the house to which recourse is to be had. When the term hujjah is used with the name of a jurist like Imam Ghazali, then the term hujjatul Islam will mean a jurist who possesses great authority, or a jurist whose opinions carry great weight in Islam. In the technical meaning, in the sense in which the jurists understand it, the term hujjah means the proof which the right of Allah has made binding for us in a manner that leaves no room for excuse. For example, the binding strength of the Quran and the Sunnah. In the sense of recourse, the technical meaning is a hujjah to which recourse is obligatory for purpose of performing legal acts. It makes no difference whether the knowledge received is definitive or is somewhat less than that. The word definitive means the strength of the narration of a tradition. This we will explain in the next few videos. We have already explained the first term, which is used for the sources of Islamic law, and now we will take up the second term, dalil. In the literal meaning, the word dalil is applied to mean a guide leading a caravan or scout finding the trail. In this sense, a directory, like a telephone directory, is called a dalil because it leads us to a number or an address. In the technical meaning, in Islamic law, in this context, the word dalil is used in two ways: dalil tafsili and dalil kulli, also called dalil ijmali. Dalil tafsili may be an individual verse of the Quran or an individual sunnah in a hadith. We may refer to it as a specific evidence, though it is sometimes translated as detailed proof. For example, the verse, "Verily prayers are enjoined on believers at stated times," is a specific evidence in the Quran that points to a hukum of Allah about the obligation of prayer. Continuing, dalil ijmali or kulli is a general evidence because it contains within it a large number of specific evidences. The Quran is a general evidence. It contains a large number of specific verses within it. So is the Sunnah, which contains within it a large number of individual sunan. The same applies to Qiyas and to Ijma. The use of the term Dalil Ijmali conforms with the meaning of source. That is, the source is being considered as a whole or in its entirety. Thus, we usually say that the four sources of Islamic law, meaning thereby the four Adilla Ijmaliya, the Quran, the Sunnah, Ijma, and Qiyas. Now we will discuss the third term as a source of Islamic law, Usul. The literal meaning of the term Asl, the plural for which is Usul, is something from which another thing originates. The term Asl also means something upon which another thing is constructed, and here it gives the meaning of foundation. Technical meaning. There are several technical applications of the word Asl. The word Asl is used for different meanings in different contexts. The viewer should be mentally prepared for understanding these different meanings as we move along. The word Asl is used to mean Dalil discussed above, foundation upon which analogy or qiyas is constructed. Asl is sometimes used in the sense of the original initial rule. Thus, the maxim says, the presumption is that initially all things are permissible. What we mean here is that something which was permissible before the coming of the Sharia may have been prohibited, but originally it was permissible. Finally, the term Asl is used in the meaning of a general principle. General principles are of two kinds, those that govern the law and those that govern interpretation. The viewer will come to understand the meaning of these two types of principles later in the course. We now turn to the second topic of the video, which is the true source of law in Islam is Allah Almighty. The sources of Islamic law are divine. The source of all laws in Islam is Allah and Allah alone. The verse of the Quran, Innil hukmu illa lillahi, verily the hukm belongs to Allah alone, is often cited in support of this. This basic rule determines the character of Islamic law and gives direction to all interpretation and ijtihad. The rule says that it is Allah's laws alone that are acceptable to the Muslim. No temporal authority can command a Muslim's obedience unless the authority is based on the commands of Allah. This is the essence of social contract within a Muslim community. The ahkam of Allah, however, are discovered through evidences leading to the ahkam. These evidences are the material sources of Islamic law. By material, we mean the things we can see, while we cannot see God. The next topic are the sources agreed upon and disputed, the complete list of sources. This is the heading for the next two slides. Here we present the complete list of sources. The jurists state that the sources of Islamic law are the Quran, the Sunnah, Ijma, consensus of legal opinion, Qiyas, analogy, Istihsan, juristic preference, Qawl al-Sahabi, the opinion of a companion, Maslaha Mursala, jurisprudential interest, Saddu Zariya, blocking lawful means to an unlawful end, Istisabul Hal, presumption of continuity of a rule referred to by a few as Istidlal, Urf, which is custom, and earlier scriptural laws in the Torah and Evangel. The sources listed above are not unanimously accepted by all schools. That brings us to the second slide of the topic, which states that secondary sources are not unanimously accepted. The jurists classify some of the sources as being agreed upon unanimously by the Sunni schools. These are the Quran, the Sunnah, Ijma, and Qiyas. Schools that did not accept the above four sources became extinct and their opinions are no longer valid. For example, the Zahiri school, which is extinct, they did not accept Qiyas as a source. There is another category of sources that are a matter of disagreement among all jurists. That is, a few schools of law accept them while the rest do not. These are Istihsan, juristic preference, Qawl al-Sahabi, the opinion of a companion, Maslaha Mursala, jurisprudential interest, Istisabul Hal, presumption of continuity, Saddu Zariya, plugging the lawful means to an unlawful end, Urf, custom, and earlier scriptural laws. The fourth topic of the video is classification of sources of Islamic law, transmitted and rational sources. The topic of classification will span the next 3 slides. It contains a lot of information which was difficult to accommodate in a single slide. Transmitted sources are the Quran, the Sunnah, and Ijma. To these are also linked the opinions of a companion and the laws of the earlier scriptures. Analogy or qiyas, maslaha, istihsan, and istisab are rational sources. The rational sources are like methods of interpretation, compared to written sources transmitted through a chain. Transmitted sources provide the basic laws and fundamental principles by indicating the detailed rules of law, like those of prayer, zakat, and inheritance. It is the detailed rules of law that indicate the fundamental principles as well. Transmitted sources provide the legal justification for the validity of other sources like analogy and maslaha. In fact, all the transmitted evidences themselves find support for their acceptance in the Quran. Transmitted sources are the basis for the extension of the law. Thus, a rule in the texts may be extended through analogy. However, a rule based on istihsan, qiyas, or maslaha cannot be extended further. This means that if you need to extend the rule again, you need to go back to the transmitted source, meaning there cannot be second generations of extensions. The transmitted sources then are the basis of the law, and it is from these that the law is extended through rational sources. Here we will deal with definitive and probable sources. The attribute of a source being definitive or probable refers to the strength of transmission of the source. That is, the way it has been transmitted by the first 3 generations. By probable, here we mean that the strength of transmission is slightly less than definitive. Further, probable is a legal category which in no way means untrue. Moving on, this classification is a subclassification of transmitted sources. In other words, a transmitted source will either be definitive or probable. Definitive by way of transmission is also referred to as qat'iyus subut. A definitive source is one that has been reported by a large group of persons from a large group of persons in the first 3 generations. It is also called tawatur. Of this definitive category is the Quran. The same is the case with the Sunnah and Ijma when they have been transmitted to us by way of tawatur. In the probable category fall individual narrations of the Sunnah and Ijma. This means that the Quran as a whole, as well as each of its verses, is definitive, that is, qat'iyus subut. Whereas in the Sunnah, some traditions or hadiths may fall in the definitive category and the rest in the probable category. All that we have said about classifications in the previous 2 slides are now going to be summarized here, so the viewer must concentrate. Primary sources are those that are unanimously agreed upon by the 4 Sunni schools. This would include analogy. Secondary sources are those that are not unanimously accepted. In other words, primary sources are those that are accepted by all the schools, while secondary sources are not accepted by all the schools. Primary sources are transmitted sources, while secondary sources are mostly rational sources. This distinction would include the opinion of a companion among the primary sources, but the previous criterion excludes it. Primary sources are definitive, while secondary sources are probable. The khabar wahid is probable. Khabar wahid is an individual narration which does not reach the level of a mutawatir hadith. Laws discovered through the primary sources may be extended with the help of the rational sources, while laws discovered through secondary sources cannot be further extended. For the secondary sources, reverse the above characteristics. The viewer may try this as an exercise. The topic, Grades of Sources of Islamic Law, is covered over 2 slides. By grades is meant the priority assigned to a source in the jurist's search for the ahkam. Writers maintain that the first source to be approached is the Quran, the second is the Sunnah, the third is ijma, consensus of legal opinion, and the fourth is analogy. Thus, it is not proper to move to another source unless the search in the prior source has been exhausted. These scholars rely upon a number of evidences to strengthen this view, in particular a tradition from Muaz, God be pleased with him, when he was sent to Yemen. A closer examination of the issue reveals that the statement about the order in which the sources are to be examined needs to be qualified somewhat. Reasons are given in the next slide. We have raised the issue to invite the viewer to understand the relationship between the sources during interpretation or ijtihad a little more deeply. In other words, it is necessary to look for a rule in the Quran and then move to the Sunnah, and upon finding the rule in the Sunnah, then move to Ijma and so on. The next slide provides the answer to this issue. Approaching the Quran and the Sunnah together, it is not possible for the jurist to understand the meaning of the text of the Quran for the derivation of the ahkam unless he has recourse to the explanation and commentary of the Quran. Ijma in the texts. A hukam is sometimes established through consensus of opinion, ijma. Ijma is considered definitive by the jurists, and the jurist taking ijtihad is bound to follow its directives. Where an issue has been settled by ijma, jurists like Imam Ghazali say that the person undertaking ijtihad must first consult ijma, as an issue once settled through ijma cannot be reopened by the interpreter. The viewer will come to understand these details as we move along in the course. General principles derived from the texts. Broad general principles that have been derived from the entire law through a process of juristic reasoning are to be preferred over the khabar wahid in certain cases. The jurist must first consult general principles before he goes to the other sources. Thus, the sources cannot be consulted in a simple order of priority advocated by some writers because ijtihad is a single seamless activity that cannot follow a rigid, assumed order.